Hello and welcome to the Fit for Privacy podcast. In this podcast, we talk to influencers so that you learn from the best. I'm your host Punit Bhatia. I help business and privacy leaders to create and deliver strategies for privacy compliance and trainings. Before we start, a quick reminder that the opinions and ideas shared in this context are not legal advice. If you need advice, you should contact a professional with your specific context. So let's get started. Hello and welcome. My name is Punit Bhatia and I wish you the best of 2021. Now that 2020 is behind us, let us hope that this new year brings a bit more normalcy. As we start the new year, I wish you good health and prosperity. This is the first episode of Fit for Privacy podcast in this year, and in this podcast I will talk about privacy changes in context of Brexit. There has been a lot of talk about UK being a third country and so on. So let's get something straight. Now, UK is not part of EU. This means EU GDPR does not apply. It seems simple, but there are some specifics, like which data protection law applies in the UK. Is GDPR applicable in the UK? Now, you probably have heard and known that UK Data Protection Act 2018 was based on EU GDPR. Now, UK has created a version of EU GDPR that is called UK GDPR. Yes. For those of you getting to terms with one GDPR, now you have two to manage. Therefore, it is relevant for us to be clear on the fact that GDPR, or more specifically EU GDPR, will be the data protection law in the EU. This will continue to protect processing of EU residents' data, and it applies to your company if your company is processing personal data of EU residents. This is where it has not changed, and this is irrespective of where your company is located. So nothing changes in context of data protection for those in the EU or those processing personal data of those in EU. Now the UK GDPR will be the data protection law in the UK. This will be protecting those in UK and shall apply to companies processing personal data of those in the UK. Now technically we can say that this will be the case irrespective of where your company is located, but it remains to be seen how much of power shall UK's Information Commissioner shall have and how far is it willing to exert its influence. No idea on how it will be, only time will tell. But one thing is certain, that you have something called UK GDPR to manage if you are processing personal data of UK citizens. And in my opinion and observation, the UK GDPR is currently the same as EU GDPR, with obvious references to EU institutions changed to UK institutions and laws. I say currently because this will over time change, as UK is not going to amend any change that EU GDPR will make, and even vice versa. So in the longer run, I do see UK GDPR and EU GDPR starting to become different. But for now, both are almost same, with references to law being to EU law or UK law. But what does this mean for businesses? What does this mean for your business? Oh, by the way, I missed to introduce myself, so let me do it so quickly, because maybe everyone does not know me. I want to think that everyone knows me, but that's not the case. My name is Punit Bhatia and I'm a privacy expert who makes privacy and data protection matters simple and understandable. I help organizations to comply with privacy laws and keep customer trust. I do this by writing books like Be Ready for GDPR, which was ranked as one of the best GDPR books by Book Authority. And I'm also the host of this podcast, that is the Fit for Privacy podcast. And I work with business and privacy leaders to develop and implement privacy strategies and provide training. Now, I can do this because I have had the good fortune of setting up a GDPR compliance program for ING Bank in Belgium. And then I was privileged enough to work with wonderful colleagues to set guide, monitor privacy compliance across retail and wholesale banking operations of ING Corporate in the Netherlands and its operations across 30 plus countries. I also had the privilege to work in Stanley Black& Decker as a global privacy manager for privacy compliance in its security operations across the globe. Now, you can imagine that I'm certified in privacy. Yes, I am certified CIPPE, CIPM, and also fellow in information privacy by IAPP. And if you want to contact me, the best way is to find me on LinkedIn and contact me. Now, coming back to how does Brexit impact business, or what do these Brexit related changes, that is the UK GDPR, mean for business? Here we need to look at a few scenarios, and let's first look at data transfers, that is transfer of data from one country, one jurisdiction to another. The GDPR has required that transfers of personal data to third countries be protected with similar standards as in the EU or better. If not, there is a need for due diligence, usage of mechanisms like adequacy decisions, standard contractual clauses, binding corporate rules, derogations, and even consent. For this reason, the data transfers from the UK to EU were based on adequacy decision, or simply, since UK was part of the EU, there was no question, there was no need for adequacy decision. But now UK is not part of EU, so it is a third country, and as of now UK has not been awarded the adequacy decision. So when adequacy decision has not been extended to the UK, what happens? Well, a 6 months period has been considered, and in my opinion UK is likely to be granted adequacy eventually. Now, will that mean 6 months? I'm not so sure, because it depends. It depends on whether UK is granted adequacy based on previously being in part of EU, that is a different process, a different yardstick, a different mechanism other than the usual adequacy process is followed, or a usual process is being followed. It is highly unlikely that this can happen in 6 months if usual process is followed. I say this because historically adequacy decisions take time. The fastest assessment of adequacy decision to date, to my knowledge, is for Argentina, that took 18 months. So if you are a business in the EU and have been transferring personal data to a processor in the UK, you have two choices. One, wait and hope for adequacy decision to be granted to the UK. Or second, you rely on alternative means like standard contractual clauses and amend your contracts. Now the question is, which one is better for you? And a short answer, a consultant's answer, is it depends on the risk. It depends on the risk and depends on the risk appetite of your company. This means if the risk is high and your appetite is low, you are better off amending the contracts and relying on standard contractual clauses. It is important to mention that the ICO, Information Commissioner's Office, the Data Protection Authority in the UK, suggested that companies should start preparing for scenario wherein UK is not awarded adequacy. Of course, in their role, they have to advise you that. If you are a large corporate and there are internal data transfers and you are doing those based on binding corporate rules, then in my opinion, you can continue to do so irrespective of adequacy decision or not. But if things change, keep an eye on it. Now, what if you are a UK company or a company in the UK and have been relying on services of a processor in the EU? This is an interesting situation. Under UK's domestic version of GDPR, which came into effect January 1, 2021, at the same time the EU GDPR ceased to apply in the UK, data may continue to flow from UK to the EEA even after the end of transition period. The UK's Information Commissioner Office, that is the ICO, has issued official guidance that indicates that transfers out of the UK, that is UK to the EEA, will remain unaffected for the time being, regardless of what happens at the end of transition period. The important part is for time being. However, UK has also stated that it intends to keep this arrangement under review. Now, what does this mean? Why will it change? Why is it kept under review? These are good questions. But for now, if you are a company in the UK and have been transferring data to the EU, I believe, and it seems good enough until you hear otherwise. So no action needed unless and until you come across a consultant who wants to sell you more and more work. Sometimes I wonder why these things are so complex. Why can't these be logical? I mean, a few weeks ago, UK was part of EU and there was no question on adequacy. But suddenly the adequacy of transfers to UK is now being questioned. But when does politics and law have been simple? Never been and never will be. So while this was about existing transfers, for your future transfers and contracts, there's one more thing you must do. If you're a company based in the UK and your contracts have references to EU GDPR, it is good time to replace those references to UK Data Protection Act, that is the UK Data Protection Regime of UK Data Protection Act 2018 and the UK GDPR. Also, if I was in your place, I would start relying on standard contractual clauses in new contracts. As a business, another change that will be noticeable for you will be one-stop shop. Now that UK is a third country, you need to notify your data protection authorities about breaches to both UK ICO as well as the one you have chosen in the EU as one-stop shop. Of course, this is only if you are a large multinational company and does not apply to small and medium-sized businesses. If you are notifying to ICO already, you continue to do that. In that case, there is no impact. So this is how it will impact your business. Next, let's look at what impact will it have on roles or appointment of roles like data protection officer and EU representative. In my opinion, there is almost no impact on appointment of a DPO or not. That will continue as is. But as regards UK or EU representative, that is appointing a UK representative or EU representative, that is something to consider. And simply put, if you are a UK company that serves EU residents, it is a good idea to consider appointing a EU representative. Now, vice versa, if you are a company of EU operating in UK, would you want to appoint a UK representative? I'm not sure. So in short, the UK now has its own version of GDPR that is referred as UK GDPR. Data transfers from UK to ICO and vice versa remain as is, but for another 6 months, and that hinges on whether the UK will be awarded an adequacy decision or not. A safer choice may seem that you start relying on standard contractual clauses. Appointment of a EU representative is worth considering if you are a company who is based in UK and serves EU residents or EU citizens or EU individuals. With that, I thank you for taking time and listening to this episode of the Fit for Privacy podcast. The Fit for Privacy podcast, if you like it, please do share it, comment about it, subscribe to it so that you can be notified about new episodes. Your support matters and we count on it because it helps us get more subscribers. And if you do not like it, do feel free to share your ideas to make it better and relevant for you by emailing me at info@punitbhatia.com, info@punitbhatia.com. Thank you once again. I wish you the best of 2021. Stay healthy, stay safe, and stay blessed. Thanks for tuning in. I hope you liked this effort. Please do click like, comment, and share. It is okay if you did not like it. Please still do make a comment and share with us what we can improve. If you have suggestions, ideas for guests, or you want to have your question answered, please email me. My email is info@punitbhatia.com. You can also share this with others, and if you do so while tagging me in, I will personally thank and acknowledge your contribution in coming episodes. Thanks once more, and look forward to seeing you back. Till then, stay safe, stay blessed, and stay happy.